at DMO, and I'll be taking it off from where we stopped last week. Over the previous weeks, we transitioned from what next after business registration, looking at series of, topics, things that can help you as a business owner. Now we've transitioned into your business and the law. And so far, we've been looking at contracts, and we've been trying to underscore the importance and the significance, of contract in any form of business relationship, whether within the business or outside the business. So far, we've looked at a few contractual agreements. We've looked at confidentiality agreement, service contract last week, and if you look at some of these contracts, they particularly pertain to, how they particularly govern the relationship between the business and then external persons, that is third parties, external parties, right? And one thing we should always refer our minds to is that, when doing business, it's very important that you actually set your house in order first, because that in itself would actually dictate how things would go with other people as well. All right. So, and that is what I'm looking at today, which is operating agreement. Operating agreement basically sets to, ensure that the house is in order, before even looking at all of those things. Yes, service contract, they are good, they are very important, they are extremely important, but you cannot neglect the operating agreement, which kind of governs the house, with reaching out to third parties and establishing a form of relationship with those third parties, right? So, like I said, today we're looking at operating agreement. This operating agreement in a partnership, they would usually call it a partnership agreement. So they're kind of similar, all right. But then we'll just go through some of the clauses that you need to, pay attention to, and a little bit of the significance of having an operating agreement, right? So now, in drafting an operating agreement, and let me not forget, in drafting this, despite all this explanation, despite all this we'll be talking about, you cannot neglect the help or the good practitioner, right? Because there are gray areas to all of these things, and you would need them to ensure that you don't have issues, like I'm sure you remember, I think the first session we had when we stated some of the legal requirements of a contract. So all these legal requirements, they find expression in each of these contracts. So it's very, very important that you engage a legal practitioner. All we're trying to do is just to make you understand the things that you should expect from anyone you might contract, because it's possible. Although let me say that anyways. But then, so let's just look at some of the clauses. And I must also say that some of these clauses are largely inexhaustive, because what I'll be looking mainly at, the ones that are principal, the ones that you would almost always find in every operating agreement or partnership agreement. All right. So one is the official name, place, and purpose of the business. That establishes, this is the name of the business, this is the place where, and the purpose of the business. Every business has a purpose, every business has a place, where it operates. Even at the point of registering with CAC, some of these things are already asked, so it will be very easy for you to provide them, right? So now another is the percentage each partner owns in the business. So in every business, right, where we have 2 or 3 business owners coming together, or 2 or 3 partners coming together to form a business or a partnership, right? The funds, is needed. We all know that funds is needed, and money is kind of like a blood. We say the customer is the blood of the business. Money too is a very important part, and this is where the partners come together, decide that, let's talk. How much can you bring? How much can you bring? How much should we bring? So each person, they bring a certain amount of money together. So it is also advisable that this is not something you can just go, sit at a restaurant and just talk with your business partner, your business partner, that you should bring 50%. Okay, we're looking at this amount of shares, this amount of share capital. Why don't you bring 50% and all those things? It's not something you just discuss and then you leave there. You consult a legal practitioner, and then you put this agreement, these things you've agreed to do in writing, so that it can be enforceable in the nearest future. Who knows, anything can happen, right? Relationship can be strained and different things can happen. So it's what you have in the agreement that keeps, that helps, that makes things easier, in the future, in case, anything happens that we didn't plan for. All right, so let's quickly get back to what I was saying. Now, the percentage each partner will bring in. So once you agree that, I'm going to bring certain percentage, you put it in writing. So this is also one of the clauses, that you would usually find in an operating agreement or a partnership agreement. All right. So another one is how much capital each is putting in. Right. So this is just how much capital, then percentage. Of course, you're just doing a little bit of calculation, right? For example, the whole thing you want to bring into a business is 100,000 naira, right? Percentage 50%. That means a person is bringing 50,000 naira, right? So you're just putting the figures and then the percentage separately. But then these clauses are usually separated. Okay, so who makes financial decisions and how they are made? So it's very, very necessary so that, like I said, to avoid issues of who gave you the right to make that kind of decision, you can't do that, so you need to consult us, all of those things, the modalities of making financial decisions or even any decision at all, right? So it is very necessary that these things are put in writing. You agree and then you put it in writing. Like I said, in future, no one knows, we've seen best of friends turn to, something we didn't even envisage, right? And things happen, life happens. So once you have something in writing, nothing changes it, right? Emotional imbalances or whatever doesn't change it. It's in writing and it remains, so it is enforceable by the law, under the law. All right. So another is how profits and losses are distributed. Now we mentioned something about the percentage of what you bring into the business. So justice, or I think in accordance with the law generally, what you put into the business is to that same extent that you're going to actually benefit in terms of profit or in terms of loss, right? So, like I'm sure you remember in the previous sessions we had many weeks ago when we talked about, limited liability, liable. So that kind of idea applies in this place, because the percentage of what you put in is the percentage of profit that you're going to get. That's the way this one works. All right. Same for losses as well. A detailed description of the management role and responsibility of each partner. So that one too is very, very necessary. The role each partner plays. All right. So there are partners that they won't really be in the business, but then they pushing capital into the business, don't operate with you. There are some that are doing certain things in the business, start doing stuff. It doesn't work like that because things change, like I said, and it's a common thing we all know. Right, so this is where the law comes in. You need to state the responsibilities of each of these people you've chosen as friends, now partners, in the business, either as a partnership or under a limited liability company. So you need to state all of these things, the role, responsibilities of each of these people. This is also one of the clauses you have, in the operating agreement. All right. Also, we have when, where, and how often official meetings to formally discuss the state of the business will occur. So you would agree with me that every business, you usually hear something like annual general meeting of S holding, for example, as a company, and there are meetings that are extraordinary general meetings, there are annual meetings, even meetings at different points in time, right? So, but then it's also very important that, despite the fact that under the law it's possible to have an extraordinary general meeting, right? But you must expressly state when, how, all of those things in your operating agreement, how it's going to go, right? You need to actually state all of this. This is a very, very important clause we need to bear in mind. All right. Now, the duration of the partnership or the business. So not everyone goes into business with the intention that we want it to outlive us. We need it to cross generations upon generations, live 100 years, 200 years, and all of those things. Some just create the business for, let's create this for 20 years and let's see what happens. And most people, they tend to, we're going to end this business like this. You need to expressly state it in the operating agreement that this business relationship or this business we're setting up is just going to be for 20 years, and after 20 years we're going to wind up. Alright, so if this is the case, you need to expressly state it in the operating agreement or the partnership agreement. Now, another is whether or how a partner can sell their shares, in the business or purchase another. Alright, so this one is also very important. How they purchase shares, and you understand that even in a company, private company, public company, there are modalities to all of these things, right? But then all of these, and also in a partnership as well. So all of this can be put in writing. You need to state how, how a partner can sell their shares, I don't really want to go into some deeper aspect of company, private company, and all of those things. But then in general, you need to state this in your agreement. You know how how you intend to sell shares. Maybe a person is pulling out. How you intend to deal with that shares the person is going to be leaving. All of those things you need to sort it out in the operating agreement, and this is why the operating agreement is very important. Okay, now we also have how and why the partnership may be dissolved. All right, this is kind of closely linked to the duration of the partnership, but they are also separately stated, right? So partnership may be dissolved on various grounds, but then you need to be actually very specific as to how and why the partnership may be dissolved. You can also state that upon the, let's say your duration of your partnership is just for 20 years, and then you state maybe at the end of this number of years we are ending this and all of those things. It's also very important to state this in the partnership agreement or the operating agreement. Alright, so we also have what happens when a partner dies. So like I said, things happen, right? Three of you come together as friends, you create a business, and then no one plans for negative things, all of these occurrences to happen, unexpected occurrences, to happen, right? And one person passes away, you need to have something on ground just in case something happens. It could be that when the person passes away, of course, there are shares on ground. What should we do with the shares? What will happen to these shares? Are we going to give it to the family? Are we going to take it up on his behalf? Or are the other partners going to buy those shares? And all of these things have to be sorted out in the operating agreement. All right. So now these are some of the clauses you would usually find in an operating agreement, but there are more. And depending on the peculiarity of your business, and this is where you also need, like I said, a legal practitioner, right? Businesses varies in terms of concept, so some of the things that goes on in variations of businesses or partnerships would necessitate certain clauses to be included in that agreement. All right, so and the importance, I think when we started this, I started by emphasizing on the importance subtly, of having, a partnership agreement or an operating agreement in your business before actually formally commencing your business. So, some of the importance in this agreement is kind of still embedded in some of the clauses we already see. Things are properly stated out. In case of future whatever thing that happen in the future, you can easily pull out the agreement and say, brother, read through this agreement. This is what we agreed, right? No emotional thing attached. The law simply applied. This is what you save yourself of, headaches and stress and all of those things. You save yourself of all of these things when you put, all of these clauses, and plus depending on the peculiarity of the business, like I said, depending on all of those things, you put all of these things in the agreement so that for future reasons you're able to bring it back and do things accordingly. All right. Now I have here for the enforcement of intentions when necessary by the court. So you understand that generally what is going to be contained in this agreement are the intentions of the partners together. You must have agreed, right? Those intentions can be put at that time. Probably your friends, you're cool. It's very easy for you guys to agree on things. But then this is where you now put it in writing so that just in case we don't pray for something like that, but then things happen, like I said, almost repeatedly. Like just in case things happen, you have something on ground. You have something that your lawyer can easily bring out and say, you agreed to this on so date of dash whatever year, right? So it is very, very important. Now, I have, like I said, for easy enforcement of intentions when necessary by the court, right? But then a court will only enforce an agreement that that passes, that ticks the legal requirements that we actually looked at, and I'm sure you can remember some of the requirements that we looked at. I think that was in the first session of this series, Your Business and the Law. We have the need to have an offer, an acceptance, consideration, intention to be that the contract be legally binding, on the parties involved. So this is where you have the operating agreement. You can just, with the word of mouth, just say, what, I feel like you should bring 50%, you bring 30, I'll bring 20, and then you just talk about it. And then when losses arise and all of those things, you're like, no, I can't take that amount of loss. And you know that according to law, the amount of I don't know, the amount of your stake in the business is also equal to the amount of losses you would get, and all of these things, and same for profit. But then you're being, oh, no, 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 I can't take that. That is, all those ones are emotional, kind of whatever. But once you have it in writing, that then that in itself now shows that you want to be legally, you want the agreement in that agreement to be legally binding on you and each of the business partners involved, right? So another is, even though it's not really usually put in, as one of the legal requirements, we have for a lawful purpose. You can't enter into a contract for an unlawful purpose. And looking at what we're talking about, we can, without any iota of doubt, say that when you're entering into an agreement to govern the relationship of those starting, that business or that partnership or that company, whatever, right? It is for a lawful purpose, and one of the things we mentioned is also the purpose of the business, right? This is where we see the things you want to do. You can't create a contract you can't create an operating agreement for an illegal business. It doesn't work. The court won't enforce it, right? And I think that is even common sense. Another is parties must be legally capable. So you must not be considered a person a person with disability under the law. You must not be an infant, all of those things, So these are the things we consider, when trying to reach a contract. And once these boxes are ticked, then your contract has no reason to be not enforced. All right. So we also know that you can also deduce from all of these things. We've said that entering into an operating agreement is necessary for smooth operation of business, right? So once your house is set in order already, relating with external parties, suppliers, and all of those things is not going to be so much of an issue, right? Your house is in order. It's easier for you to relate with other people, business-wise. All right. It also clarifies, I think I mentioned this earlier also, it clarifies the purpose of the business and important terms and clauses based on the peculiarity of your business. So these are some of the clauses. They are more, like I said, and depending on the peculiarity of the business, you can always reach out to a legal practitioner to help you out, in drafting, based on the consultation and all of those things. So now this will be the end of this session, and if there's anything I would like to reiterate in all of the sessions we've been having, right, is that there's hearing on one side, and then there's the doing. So it's very important that we don't just hear some of these things, but we do them. This is when we benefit from the law. This is when we're not disadvantaged. All right. So, and one more thing, if we've had series of sessions in the past, so I advise, if you're just joining us today, please check out some of the other sessions we've had in the past. I'm sure it will really help your business, because this is why we're here for you. We're here to see your business thrive beyond your widest imaginations, right? So now it's very important that you check out some of these things and then you put it to action in your business, and when necessary, you reach out to legal practitioners, because there are gray areas to all of these things, right? So reach out to legal practitioners to help you out in implementing some of these things, and then you won't have any issues. So I wish you the best in your business journey, and that'll be all for this afternoon. Thank you for joining me. I'm Daniel Olukayode Ademo.